I want to thank everybody for coming tonight. My name is Mary Rice. I'm the president of League of Women Voters in Bloomington. This event is co-sponsored by the League of Women Voters Edina, League of Women Voters East Carver County, Richfield, and we had assistance with marketing this event by League of Women Voters of Minnetonka, Eden Prairie, and Hopkins. So thank you to all of the co-sponsors. I also want to thank our forum committee. It was a lot of work putting this forum together, and we're really excited about it. And I especially want to thank Denise Royer and Lisa Sterrett, who were the committee chairs. I want to thank Lonnie Skretner from League of Women Voters Edina. She spent probably most of the last day and a half going through the SurveyMonkey questions that came in. I think maybe 70 came in. And we've got a half-hour panel discussion at the end. So thank you, everybody who sent in your questions. We hope you'll have more tonight. That's what your cards are for. And any question you want to write down, please do so, and we'll sort through those as well. I want to thank Suzanne Kienitz for doing the graphics and putting our marketing materials together. Thanks to the City of Bloomington and Elizabeth Tolsman especially for the use of this space and also for helping with logistics. I want to thank Jill Murphy and her crew for setup and takedown and for AV assistance. I also want to thank Grant Hill and Bloomington Cable. This event is going to be broadcast on cable. And I also want to thank our moderator, Gretchen Musicant, and our 4 speakers and their organizations for participating and doing all the preparation that was necessary for this evening's event. The League of Women Voters is a nonprofit political organization that never endorses any political party or any political candidate. Our purpose is to grow the vote, protect the vote, and empower the vote. We're presenting this forum in order to provide information and arguments on both sides of these controversial issues surrounding guns. And our hope is that it will better inform all of our votes at both the state and national levels. The forum is intended to be a balanced discussion. In the interest of full disclosure, though, and our speakers know this, the League of Women Voters does have a position on gun control. The League of Women Voters does have positions on certain issues, and those positions are arrived at by doing consensus studies at a grassroots level that goes to the state level and then the national level. The position of the League of Women Voters on gun control is contained in the inside cover of your materials, and this is how it reads. The League of Women Voters of the United States believes that the proliferation of handguns and semi-automatic assault weapons in the United States is a major health and safety threat to its citizens. The League supports strong federal measures to limit the accessibility and regulate the ownership of these weapons by private citizens. The League supports regulating firearms for consumer safety. The League supports licensing procedures for gun ownership by private citizens to include a waiting period for background checks, personal identity verification, gun safety education, and annual license renewal. The license fee should be adequate to bear the costs of education and verification. The League supports a ban on Saturday night specials, enforcement of strict penalties for improper possession of and crimes committed with handguns and assault weapons, and allocation of resources to better regulate and monitor gun dealers. That's the position of the League, that's our position, and we're not going to argue it any further in this forum. This forum is intended to be a neutral forum and a balanced discussion of the issues. The first thing we're going to do is provide background on the First Amendment. Professor Michael Steenson from Mitchell-Hamlin Law School will discuss the Second Amendment and Supreme Court decisions on the amendment. He will provide us with what has been decided under the Second Amendment and what's left open. This background provided by Professor Steenson will probably answer some questions for all of us, but it's also probably going to raise some new questions. Professor Michael Steenson is the Bell Distinguished Professor of Law at Mitchell-Hamlin School of Law. He's a graduate of the University of Wisconsin and the University of Iowa School of Law. Professor Steenson is a member of the American Law Institute and a fellow of the American Bar Foundation. He teaches in the area of torts, constitutional law, and American legal history. Following the Second Amendment overview, which will take about 15 minutes, two state issues and 3 federal issues will be addressed in a different way by discussion on both sides of each issue. Each side will have the same amount of time, and the discussion will be a balanced discussion. We're pleased to have Minneapolis Health Commissioner Gretchen Musicant here to moderate. She has a Bachelor of Science in Nursing and a Master's in Public Health from the University of Minnesota. Her public policy experience includes state-level lobbying and a fellowship with the Humphrey Institute. She's been awarded the University of Minnesota Gaylord Anderson Award for Leadership in Public Health, the Paul and Sheila Wellstone Public Health Achievement Award, and is one of the 100 distinguished University of Minnesota nursing alumni. As I was preparing for this and thinking about this forum and the diverse issues on these topics, these topics are controversial topics. It brought to mind something I saw when I was viewing Humans of New York. I don't know if anybody here is familiar with that. There's a book on it, and there's a website, Humans of New York. And what it is there's a photographer in New York City who just photographs and interviews people on the street. And one of the interviews had a dialogue like this that I thought was appropriate for tonight. The person he was talking to said, "I want to change the world, but I don't know how." His response was, "Do you mind if I give you a piece of advice?" She said, "Sure." He said, "Read books by people you disagree with." Well, tonight, I think most everybody here has a position on one side or another of some of these issues. And let's listen to the people we agree with, but let's also listen to the people we don't agree with. Let's show that here in Bloomington, we can have a civil and a respectful discussion despite our differences. If we can achieve a little better understanding of the issues, and of where those with whom we disagree are coming from, maybe someday we'll be able to take a step towards solution of some of the issues. So with that, I'll turn this over to Professor Steenson. Thank you.
Thanks, Mary. Thank you, and good evening. How many of you have read Heller versus Doe and McDonald versus City of Chicago? Okay. And you've all read Second Amendment, right? Well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. All right, so the question is just exactly what does that mean? And it took a long time for the Supreme Court to get around to deciding Heller versus Doe. But as Justice Scalia pointed out in his opinion in the Heller case, that's not surprising. It took the court a long time to interpret other amendments. Now, of course, the Second Amendment is included in the Bill of Rights. It's ratified in 1791. But it took a long, long time for the Supreme Court to declare a law violative of the First Amendment, the Free Speech Clause, not until 1931 in Neer versus Minnesota. So we're sort of at the dawn of a new understanding of what the Second Amendment means. There have been arguments about what the Second Amendment means all along, but the typical understanding that the right to keep and bear arms only existed in connection with a well-regulated militia was completely scotched in the Heller case. Right to keep and bear arms is a separate and independent right. It's a fundamental right. The right to keep and bear arms is a right very much like the First Amendment right. Now take a look at the way the First Amendment reads. Now this amendment seems to be framed in absolute terms, so this is one thing I want you to think about. It says the right to keep and bear arms shall not be infringed. Never, or if so, under what circumstances? Well, the First Amendment seems to say the same thing. Congress shall make no law, and of course the First Amendment also applies to the states. Well, does that mean that Congress shall make no law? Or are there perhaps some limitations? You might have a right to free speech. You might have a right to protest government action, but you don't have a right to do it in front of my house at 2 o'clock in the morning on a bullhorn. So there are time, place, and manner regulations, of course, that are going to be allowed, even if free speech is being regulated. Some expression is simply going to be carved out from the protection of the First Amendment. Two examples are obscenity and child pornography. So the question is whether or not there are some limitations on Second Amendment rights. So we'll talk about that also. But what I want to do is to very quickly walk through the Heller case, District of Columbia versus Heller. This involved the constitutionality of a rigid gun law in the District of Columbia, and the District of Columbia has obviously some major crime problems. All right, so the District of Columbia generally prohibits the possession of handguns. It's a crime in the District of Columbia to carry an unregistered firearm, and the registration of handguns is prohibited. Well, that substantially limits the right. Okay, no person may carry a handgun without a license. Chief of police might issue a license for a 1-year period. All right, and residents also have to keep their firearms locked up, all right, even at home, which would substantially compromise the right to self-defense. All right, so that's the basis for the challenge to the Second Amendment, or the challenge to the D.C. regulations. It's based upon the Second Amendment. Heller says this violates his Second Amendment rights. All right, so he brought suit against the District of Columbia and sought to enjoin the regulations. All right, now he wins in the case, and he wins big. The case involves the meaning of the Second Amendment. Is the right to keep and bear arms a right only in connection with a well-regulated militia, or is the right to keep and bear arms not so much separate and independent, but a fundamental right all by itself? The right to keep and bear arms, a fundamental right, a right pre-existing the adoption of the Constitution, just like the right to free speech. The answer is, of course, that it is. Justice Scalia, and this was a very, very close case, hotly contested case, 5-4 opinion. Justice Scalia, of course, no longer on the court, wrote for the court in this particular case. There's a Second Amendment right to keep and bear arms. And the ban on handgun possession in this particular case violates the Second Amendment, Justice Scalia says. Statutory prohibition here against rendering any lawful firearm in the house inoperable violates a core Second Amendment right to keep and bear arms. Now, one of the interesting things about this case is that Justice Scalia says the constitutional provision, the Second Amendment, has to be interpreted in light of what the framers thought. All right, now I want you to think about that for just a moment. How do we know what the Second Amendment means? If we just took those few words, well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. If we look just at those words, we're going to get all sorts of different interpretations. So one of the major issues with respect to constitutional interpretation is, how do we decide what a constitutional provision means? Well, this is where a concept called original intent, sometimes, or originalism comes into play. We have to have an anchor in the Constitution. And that anchor is to try to figure out what the meaning of the words was at the time the constitutional provision or amendment was adopted. Otherwise, as the court has said on many other occasions, otherwise the Constitution is nothing other than what 5 justices say it is, and that may vary significantly from case to case and from court to court. Composition of the court, of course, changes. All right, so to anchor constitutional interpretation firmly in the Constitution, Justice Scalia says we have to figure out what the meaning of these words was at the time the constitutional provision was adopted. And it does make sense. So both the majority and the dissenting opinions focus on the originalist meaning, originalism, not original intent, but the original meaning, the original understanding of the Second Amendment at the time it was adopted. All right, now, I suppose the easiest thing to do is just to take a quick look at these terms. Justice Scalia looks at them in detail, what the right of the people means, what keep and bear arms means, what arms were. And he determines this by taking a look at all sorts of sources, not only before the Second Amendment was adopted, but after the Second Amendment was adopted and after the 14th Amendment was adopted. If you take a look at Heller versus Doe, and I would highly recommend as an exercise in your understanding of how the Constitution works and how courts interpret it, read Heller versus Doe. You might wonder why the Supreme Court possibly cares about what happened in Stuart, England in 1689 when Parliament adopted a Declaration of Rights. Well, it has to do with what the meaning of the constitutional provision was at or about that time, what the framers were worried about. If the English wanted to provide for this fundamental right of people to keep and bear arms, then it's a pretty good bet that the framers intended to rely on the notion that people have a right to keep and bear arms as a fundamental right. Right to keep and bear arms for hunting, right to keep and bear arms for self-defense. So Justice Scalia takes a long, hard look, as do the dissenting opinions, of what the original meaning was. They come to opposite conclusions pretty clearly. All right, now, essentially what Justice Scalia says is that, well, of course, Second Amendment rights were protected in order to preserve the existence of a militia. And why the militia? Well, framers were very much afraid of standing armies. They'd seen what happened in England. Great fear was standing armies. All right, so they wanted to make sure that the militia would guard against the possibility of the accumulation of power by the central federal government and the imposition of tyranny. All right, so that's why we need the militia, but that wasn't the only reason why the framers adopted this particular right. There's this separate and independent fundamental right to keep and bear arms, and it is a right very much like the right to free speech. Whether you like the right or not, it's a fundamental right. It's a pre-existing right. Okay, but it's also, obviously, not an unlimited right, as Justice Scalia points out in this particular case. All right, now, there are some situations where regulation is going to be permitted. Now, we don't have an exhaustive laundry list, but keep in mind that this is the first case that the courts had in a long time since United States versus Miller in 1939 to really take a hard look at the Second Amendment and to determine that there is this fundamental right to keep and bear arms. So a court, when it's initially examining a particular issue, isn't going to set out a laundry list of exceptions. It's not going to be likely to set out a determinative or a definitive standard of review. The court's going to take the law on a case-by-case basis. That's how constitutional law gets developed. The Supreme Court doesn't sit there and decide that, well, October term 2017, we're going to take care of Second Amendment cases. They only take the cases that come to them. Constitutional law develops on a case-by-case basis. Second Amendment law is going to be in the making for a long, long time. First Amendment law is still in the making, even though there are a significant number of cases on the issue. Okay, so what are the potential limitations? Justice Scalia says that there are these long-standing prohibitions on the possession of firearms by felons and the mentally ill. They shouldn't be entitled to possess handguns, although these are simply presumptions. These are not absolutes by any means. Laws forbidding the carrying of firearms in sensitive places, schools and government buildings, he says. Laws, conditions, and qualifications on the commercial sale of arms. All right, so he's suggesting that these are historical limitations on the right to keep and bear arms. They're presumptively unlawful. But keep in mind that because these limitations are presumptively unlawful, they can be challenged. A presumption is just that, a presumption. It doesn't mean that it's absolute. And so, in fact, you do see people who have at one time been declared mentally ill challenging restrictions keeping firearms from them when they've shown quite clearly that they've rehabilitated themselves. Convicted felons, felons who are convicted of dangerous crimes, have no chance at all. At least that's the way the case law has been playing out. All right, now the court said another important limitation on the right to keep and bear arms is that the weapons have to be the kind that were in common use at the time. All right, well, now what does that mean, common use at the time? Does that mean that if you want to possess a weapon in your home, it has to be a black powder muzzle loader? Or do you get to keep and bear arms in the sense of modern firearms. And it's quite clear from the court's opinion that common use at the time has to be taken with a contemporary understanding. So people aren't limited just to the kinds of arms that existed at the time the Second Amendment was adopted, but equivalent kinds of arms. We have to allow room for movement in the Second Amendment. All right, now the court also says it's fairly supported by historical tradition that people ought not to be able to carry dangerous and unusual weapons. All right, well, all weapons are dangerous, right? So this concept has to be construed in connection with the notion of whether or not the weapons are in common use at the time. But again, it's not limited to muzzle-loading muskets. Modern interpretations, kinds of weapons commonly used for self-defense would be handguns in the home, all right? So they presumably wouldn't be exempted from protection by the Second Amendment. All right, so the standard of review, and this is a major issue in this case, as it is in constitutional cases in general. There are three basic standards of review, and it would really sound very confusing. Well, it would sound very confusing if you were a law student, but even more confusing if you're not. But basically the question is this: should courts apply some sort of heightened scrutiny in evaluating laws that infringe on Second Amendment rights, or something called rational basis review, where there's substantial deference to the legislature? The more restrictive the standard of review, the less latitude the legislature gets. Less restrictive, the more latitude the legislature gets. All right, now Justice Scalia didn't apply any particular standard of review, and this has really created problems for the lower courts since the Heller decision. But Justice Scalia says these regulations, which relate to the core of the First Amendment, the right to keep and bear arms at home for self-defense purposes, is at the core of the First Amendment. Well, I don't care what the standard of review is, he says. This law would be unconstitutional under any of those standards, but he leaves the question open. All right, now maybe he should have resolved the question, but why? Why? We need more case law. We need to have the lower courts consider these questions before the Supreme Court of the United States is going to take a clear position on what the standard of review ought to be. And as a matter of fact, the way it's shaking out is the courts have applied a sort of intermediate level of scrutiny. Some deference, but not complete deference, to legislatures in regulating handguns. Some, but not complete deference. All right, now, this is the holding in the case. All right, so there is a core right to keep and bear arms for self-defense purposes. How broad this right is going to be construed is being worked out now in dozens and hundreds, literally hundreds of cases challenging state regulation, state and local regulation of handgun possession. There are all sorts of issues that arise. All right, now Justice Stevens dissents in this particular case. Justice Stevens says that his reading, and he's looking at the same historical evidence as Justice Scalia. Justice Stevens says right to keep and bear arms only exists in connection with a well-regulated militia. All right, now we're getting close, I think, to our 15-minute time period, so I'm going to move through this pretty quickly. He says that the regulation exists only with respect to the right to keep and bear arms in connection with a well-regulated militia. There is no fundamental right to keep and bear arms, but keep in mind that he dissented. Justice Breyer, in this case, says, well, standard of review, we don't know what the standard of review is, but it can't be a strict scrutiny standard of review, and even if it is, there's necessarily going to have to be balancing of interests. The state's interest, preventing violence, interest of the individual in possessing weapons for self-defense. Since balancing is inherently necessary, let's just simply adopt the balancing test. All right, so that's his suggestion, and in fact, that's essentially what's playing out in the lower courts. All right, now the 14th Amendment, this is my attempt to illustrate how the Bill of Rights applies. 14th Amendment in 1868 provides for due process of law. Through the 14th Amendment, the court has engaged in something called selective incorporation, in which it's applied some of the Bill of Rights, but not all of the Bill of Rights. I mean, when was the last time that the state tried to quarter soldiers in your home, for example. For me, it's been months, I think, since then. All right, so what the court said in the McDonald case is that this fundamental right to keep and bear arms for self-defense is implicit in the concept of ordered liberty, and it applies through the states through the window that's opened by the 14th Amendment. So the Second Amendment fully applies to the states. That's McDonald versus City of Chicago. Now, the last thing that I'll mention is this concept. The Second Amendment establishes a baseline. States can't drop below it. States can't infringe this fundamental right. Well, we need to know what the contours are of the fundamental right. States can't drop below that line. They can go above the line. States can, as much as they choose, make possession, carrying of handguns completely open, or any other weapons for that matter. States, if they choose to do so, can eliminate any regulations of firearms. Kansas would be a really good example. All right, that does not run afoul of the Second Amendment. You can't drop below the line. You can go above the line. Regulate as much as you want. All right? Now, Guitron Guizar is helpful because it sets out the kinds of questions that arise. Who gets covered? What gets covered? What's the where of handgun regulations? Where can people, or firearms regulations, where can people carry? When can they carry? Why can they carry? These are the issues that the lower courts are working through. And you see some of the most incredibly detailed opinions, particularly in the Federal Court of Appeals. One written by the Sixth Circuit, 60 pages long, 230 footnotes, relating to just one single statutory regulation of firearms. All right, so this litigation is roiling in the courts now. Eventually, probably not this next term, but when we go to full Supreme Court, eventually, if there's enough of a conflict among the Circuit Court of Appeals, the Supreme Court will take a case and we'll get some greater enlightenment. The court's had one case, by the way, and it's sort of a minor case involving the issue of whether or not Massachusetts could prevent the prohibition against carrying stun guns as a dangerous weapon. Well, stun guns, don't know that they existed. I mean, of course, 1752, Ben Franklin's flying kites and trying to trap electricity in a Leyden jar. People didn't have stun guns then. But that doesn't mean that those aren't weapons that are commonly used for self-defense now. So the court held in that particular case that Massachusetts couldn't regulate the possession of stun guns for personal self-defense. Well, all right. So the courts have an awful long way to go, and we're really just at sort of the dawn of Second Amendment interpretation. All right. Thank you.
Thank you, Professor. I feel like I might need some legal credit or something, some credit for taking a legal class. That was rich. That was rich and deep. Thank you. So I'm Gretchen Musicant, and you've heard me introduced. Thank you all for attending tonight, this kind of chilly and wet night. I'm glad to see you all here. I'd like, if you haven't already done so, for you to think about your cell phone and check and see if it's turned off. Appreciate that if you would do that. So the purpose of this evening's forum is to have a civil and informative discussion on the issues related to guns. Our goal is to address both sides of the issues with facts and discussion about specific proposed state and federal legislation to help voters make informed decisions. The views expressed in this forum will be those of the speakers and not of the League of Women Voters. All right. As I thought about moderating tonight, it occurred to me that each one of us who came out on this evening to attend this forum comes with some primary frame of reference, a main referent point or viewpoint that we approach issues about guns with. And so I want you to pause for a second and think about naming yours. It might be self-protection. It might be preventing injury. And so as a public health professional, that's probably mine. It might be about people's rights. It might be as a collector and as someone who admires the mechanism of a gun. It might be out of affiliation with others who share our same viewpoints. I think if we think about our own frame, it will help us listen tonight and listen for those places where there are common threads even amongst and between the frames that we bring into the room, where they overlap, and probably where they're oppositional as well. So I just want you to have that little mental exercise while we're listening to our speakers. Before we started tonight, there was a coin toss to determine who will speak first, who will speak second. First speakers will get 4.5 minutes, second speaker will get 6 minutes, and then the first speaker gets another 1.5 minutes after the second speaker. So there's 3 segments to the presentation on each topic. We have league volunteers who are keeping track of the time, and they will be holding up signs, and so I will try and pay attention, and the speakers, I hope, will try and pay attention as well, but wave them if you need to. And we have, as you know, invited people to submit questions beforehand, but submitting questions also today on the cards that were in your packets. All written questions become the property of the League of Women Voters in Bloomington. This forum is being videotaped, as you heard already, and please hold your applause until the end of the forum so that speakers have more time. Speakers, please speak into the microphone to make sure that we can all hear what you have to say. Now I'm going to introduce tonight's speakers. First on the panel is Sarah Cade. She's a healthcare professional, competitive pistol shooter, and volunteer activist. A strong advocate for the responsible gun ownership, she serves as a team leader for the Minnesota Gun Owners Caucus. She brings a unique perspective on how gun laws affect the next generation of gun owners, who are increasingly female, non-white, and urban dwelling. The next person I'm introducing is one person over from her, Paul Schnell, who became chief of police for Maplewood, Minnesota Police Department on July 2013. He has also held law enforcement positions in Hastings, St. Paul, and Carver County, Minnesota. He's an adjunct faculty member at both the University of St. Thomas and St. Catherine University, as well as Metropolitan State University. He holds a Bachelor of Social Work degree from the University of St. Thomas and a master's degree in organizational leadership from St. Catherine University. He is both a Minnesota licensed peace officer and a social worker. He is a member of the Minnesota Chief of Police Association. Those two speakers will be addressing state issues. On federal issues, at the far end of the panel is Reverend Nancy Nord-Bentz. She is an ordained Lutheran pastor who felt called to leave parish ministry and join the gun reform movement after officiating at 6 funerals for gun violence victims. She now serves as executive director of Protect Minnesota, the only independent, state-based gun violence prevention organization in Minnesota. And finally, Brian Strausser, who is over here in the middle, in the absolute middle, is chairman of the Minnesota Gun Owners Caucus and is affiliated, and its affiliated political action committee. In his day job, Brian serves as CEO of a Minneapolis-based global strategic advisory firm. Brian holds a BS in criminal justice and a master's in business administration. He is a graduate of the National Preparedness Leadership Program at Harvard JFK School of Government, and he was recently named a Humphrey Policy Fellow at the University of Minnesota. So, let us now begin. The first issue that we are going to hear about is a state-level issue. It's on background checks on firearm transfer. And the first speaker will be, I've lost my notes here, just a second.
I don't know.
And they're out of order. Bear with me, Paul Schnell, I'm sorry. He will be the first speaker on state legislation, and Sarah Cade will be the second. Please begin.
All right. Well, thank you all for being here. It's great to have this opportunity. These are complicated issues, and I think when we look at this one, I want to talk specifically about the background check legislation that has been proposed. This really was set up and established as a means of beginning to close some of the common loopholes we have around access to firearms in the state. The majority of people here, the majority of people who purchase and own firearms do that lawfully. They go out and they make a purchase, they submit to a background check as part of that process, and there isn't an issue. And this protects us. The research indicates that background checks do have real benefit and real merit, and they do add to the safety of our communities. As someone who routinely reviews requests for permits to purchase, which really is a form of a background check, I can tell you that it is not an uncommon occurrence to have people who you would think would know that they shouldn't be able to purchase these guns to come in, submit an application, and be rejected as a part of that. But the way around that is simply to go purchase that gun from a private party where there is simply a transfer. There is a mechanism in the existing law which does not happen. It does not submit to a background check. There is not this transfer permit process that is established. It simply doesn't happen. It hasn't worked. It's not effective. It doesn't allow us to kind of really fully know what's happened. And so this law that is being proposed essentially creates a mechanism that would require that, with a few exceptions, all purchases of firearms would have to go through a background check. They would do that through a federally licensed firearms dealer, which are plentiful and out there, and which is where most of us buy our weapons. There are provisions for some transfer across family members. There are some transfers for active law enforcement, active military to transfer these firearms without this process being put into place. But it also establishes some penalties, and those penalties really address the issues. One of the really significant issues I think that we face, and that is the issue of straw buyers. Those people who go out and they make some of these purchases, they transfer these guns without a background check knowingly, and then what ends up happening is that these are oftentimes the cases that affect us. I think we can think back of the incident that occurred in I think the New Hope City Hall was an example of a case where there was a straw purchase that was done. That gun was transferred to that man, and in the current law, that would be something that simply did not get caught. If there was a next check, a check that would have occurred, potentially that incident could have been prevented. Last thing I want to just say before I turn it over to Sarah, you get somebody who's super competent after me, but is just to say this, that at the end of the day, we know that these background checks, they work, they're effective. It's simple. It's not burdensome. I've purchased many guns. I am a gun owner, obviously. It's part of my job, but I come from a long family of hunters and sportsmen, and so I think This is a reasonable provision under the law and something that certainly should be supported for the safety of our communities.
Thank you. Now, Sarah?
Hello, my name is Sarah Cade, and I am the gun lobby. It's kind of funny because I'm just like this normal person. I work in a hospital, I shoot guns as a hobby, and I'm a volunteer advocate for a couple of different causes. I don't work in the gun industry at all. Unlike some of our opposition tonight, I'm not being paid to be here. I wrote my speech myself. I didn't get a list of talking points from any well-funded out-of-state lobbying groups. I've lived in Minnesota for 26 years, and this is my home. I care about what happens here. So this is what the gun lobby looks like. I'm here today because I believe the Second Amendment protects an important human right. I want to help people understand the reasonable, common sense objections to these laws. So let's start with language. You're going to hear a few buzzwords and phrases tonight: common sense, reasonable, reducing gun violence, closing loopholes, and making a difference. There are two words you're not going to hear, and those are gun control. Those buzzwords came from a focus group in Edina paid for by an out-of-state group. They wanted to figure out how to make gun control sound more palatable to you guys. So anytime you hear those phrases, I'd like you to just listen very critically, and feel free if you want to make a drinking game out of it, go right ahead. Personally, I've been a reproductive freedom advocate for longer than I've been a Second Amendment advocate. So it struck me right away that both of these issues have a very common theme. And that is, how do you protect a civil right that is controversial? Turns out we know exactly what happens when civil rights become unpopular. If you look at access to abortion in red states, you see incremental restrictions in the name of protecting women. And that's everything from targeted safety regulations to privacy violations to restrictive zoning. If they can't attack the right directly, they will attack it sideways. Even moderates will agree to restrictions if you make it sound less threatening. So there's that language point again. Cheers. Hillary Clinton said, "Any right that requires you to take extraordinary measures to access it is no right at all." That quote gets to the core of the gun debate as well, and it's why I'm skeptical of burdening civil rights in the name of safety. You might have heard that gun shops in Minnesota are more common than McDonald's. You might have heard that there are over 1,000 FFLs, and all Minnesotans live within 10 minutes of one, and that's actually very misleading. 72% of FFLs in Minnesota are private businesses that are run out of somebody's home. They're not generally open to the public, and they don't generally have regular hours. Zoning laws have pushed all of the gun shops out of the Twin Cities. Since 20% of Minneapolis families don't own cars, that can mean an hour bus ride to the nearest gun shop, or a cab fare that costs more than the background check itself. For rural Minnesotans, it can mean long drives. So these aren't just simple transfers that you can just go right on down to the local Walmart to do. Walmart is not obligated to do background checks, and in fact, they don't do background checks for private sales. So it's not quite as simple as you might think. When you factor in the cost of lost time, transportation, and childcare, it's clear that these hidden costs can be significant. If your check gets delayed, you can double those costs, since you'll have to make another trip. And that's actually pretty common. So nationwide, 2.4 million sales were prevented by background checks. But what they don't tell you about that is that 94% of them were essentially clerical errors that are immediately dropped. So I have a lot of friends that get delayed every time they go to buy a gun, even though they don't even have so much as a speeding ticket. So all of those factors add up to significant hurdles for low-income Minnesotans who want to exercise their constitutional rights. And some people kind of belittle those obstacles, saying they're just minor inconveniences, these laws are so reasonable, how can anyone possibly object? Well, those people are lucky that they have the privilege to view those restrictions as minor inconveniences. There's a reason the Supreme Court said in Planned Parenthood versus Casey, the proper focus of constitutional inquiry is the group for whom the law is a restriction, not the group for whom it's irrelevant. If we burden the rights of some Minnesotans, we attack the liberty of all Minnesotans. Next, let's look at enforcement. This law is unenforceable until a person either commits a crime or has an interaction with law enforcement. And does that set off alarm bells for anyone else? The ACLU found that Minneapolis already has severe racial disparities in low-level arrests. So creating a new class of criminals hurts marginalized communities that are already disproportionately arrested, over-prosecuted, and over-sentenced. Let's be clear about what closing loopholes really means. It means creating new crimes for ordinary transfers, even when no harm has occurred. I think it goes without saying that the brunt of that enforcement is going to be borne by people who look like me. I have a real problem with civil rights violations deceptively presented as safety reforms by people who mistake correlation for causation and oversimplify complex issues. For example, you'll hear a lot of statistics from other states. States with background checks have fewer suicides, and you're supposed to assume it's because of the background checks, but did you know that those states also score highest on a combined ranking that factors in access to mental health care and the prevalence of mental illness? It's correlation versus causation. The bottom line is that this law places a large burden on low-income Minnesotans for relatively little gain. Constitutional rights are for everyone, not privileges for the elite. In the words of Mitch Berg, one of the founding principles of our country is that we are a nation of equals, where every man is a king. We're full participants not only in our own governance, but in a real sense endowed with the powers of kings. The power to participate, to protect ourselves and our communities from the worst of human nature, and to truly rule ourselves.
Thank you, Sarah. Chief Schnell, did you have some additional comments you'd like to make? There is another minute and a half you can use.
I'm going to make it very quick. I respect Sarah's position here. I don't belittle the inconveniences that this law may create for some. I don't belittle that. But as somebody who has spent a considerable amount of time responding to and even investigating incidents of gun violence, and looking at the implications of the harm that actually really happens with people losing their lives and people being adversely impacted, I think this is the place of the balancing. This is at some level the essence of the social contract, and that social contract is grounded in real people's real lives and whether or not they survive.
Thank you. So our next topic on state legislation is gun violence restraining orders, and the rules are that we'll change the order, and so Sarah will get to go first.
All right. So, gun violence restraining orders. The first thing you need to know about them is that the law is redundant. Current Minnesota law already allows for any family or household member to get an order of protection, which can require the accuser to surrender firearms after a hearing. A person showing signs of violence can be placed on a 72-hour hold, and there's a court process to adjudicate someone mentally ill, chemically dependent, or dangerous. All of these actions include some form of due process. None of them are perfect, but that doesn't mean we can't make a difference by working to improve them. See, there's that language thing again. So you might also hear this bill referred to as a red flag order. And again, that terminology was engineered by the focus group in Edina. They found out that Minnesotans happen to like our civil rights, and we thought the term gun violence restraining order sounded a little too much like punishing someone before a crime has been committed. Well, it turns out we were right, because if you actually read the bill that was introduced last session, you'll see that preemptive punishment is exactly the problem with it. Under this law, a person's constitutional rights could be suspended without due process in a secret hearing with no representation and no opportunity to present evidence on their own behalf, by the request, even possibly of an anonymous person. The language of this law is broad, and the standard of evidence is weak. Grounds could include things like a nonviolent alcohol or drug offense, failure to pay child support, and prior arrest for a felony or misdemeanor offense. That's arrest, not conviction. Once accused, the subject of the order is guilty until proven innocent and would have to go to court after the fact to get their firearms back. So obviously this is a massive violation of a citizen's right to due process. Constitutional rights cannot be removed without some form of due process. And I know it's tempting to say it could hypothetically save lives, so why do we care about the technicalities? But when evaluating any new legislation, it's always a best practice to imagine how that law could be abused before signing on to give the government more power. So even if the current administration is friendly towards you, the next one might not be. Which brings us back to that earlier point about how do you exercise a controversial right. Due process protects all of us from having our rights removed arbitrarily on flimsy evidence or because of a grudge. It gives us the right to representation and to present our side of the story. And a personal example for you, I happen to live in Maplewood. Chief Schnell is the police chief of Maplewood. And you can see there's an inherent power balance there. Because due process protects my rights from being removed on a whim, I'm free to speak out in opposition to Chief Schnell without fear of retaliation. Laws that are designed to protect citizens from government are protecting me directly right now. And they also protect any one of you if you decide that you want to speak out too. Now, by all accounts, Chief Schnell is a stand-up guy. We've spoken before, and we actually get along really well in spite of our philosophical differences. And he's done a great job as the police chief of my city. Even so, I still want the protection of the legal system in case the next chief isn't quite so accommodating. The best way to make a change in the world is to focus on where you agree. Chief Schnell mentioned in April that the gun violence restraining order is a temporary infringement, while a civil commitment, although it requires due process, can have long-lasting ramifications. And that's a really good point. I agree that temporary problems need temporary solutions, especially in the case of a mental health crisis, which might be circumstantial in nature. I think we should change existing laws to add the option for the consequences of civil commitment to expire. This would address the problem directly, including due process, rather than sidestepping it with a new law that is ripe for abuse. Thank you.
Thank you. You'll have a few minutes after Chief Schnell has his time to tell us about his position. Chief, please.
All right, Sarah was so nice. I was thinking about standing down for a minute here and just, so I really appreciate that. No, I do. I think that's, we're all people here, and that's what makes these things tough. I want to ground this in, and this is not, I've shared this before, but for me and I think for many of my colleagues around the state, I think this is what makes this so difficult. Imagine that on a Friday night, you get called to a call where there is a intoxicated person who's also kind of expressing considerable suicidal ideation. Ultimately, the man is taken to the hospital, and at the request of family who called you there in the first place, the guns are held for safekeeping. As is often the case, that person is released on Sunday, and on Monday morning you receive a call from the parents saying, please, whatever you do, do not release those guns. In this particular case, when that young man shows up at your office to say, I want my guns returned, they have to be returned despite the fact that his own family members know that he is in a bad place and requires some level of intervention. The people who should know him best are in a position where, unlike the order for protection, in this case, an order for protection is to protect me. But in the parent's concern in this situation may in fact be to protect their own child. And that's a different provision than what the current order for protection law allows, number one. Number two is order for protection laws, this mimics what happens and what has been longstanding practice in Minnesota and elsewhere. It is an ex parte order, which Sarah's right, is that a parent, a family member could petition the court based on an affidavit that gets completed, identifying a series of kind of issues or concerns, and ultimately have an order issued by the court that upon service would become valid and would require that the guns be turned over, in this case, to a variety of different, there's several options for the person to turn those over or for law enforcement to obtain them or hold them. Within 14 days, which is as the case is with orders for protection today, the due process mechanism falls into place and the person is allowed to come back into court and present evidence as to why they believe they should not be prohibited. We call this, in Minnesota, the law was created as a gun violence protection order, as opposed to think of it from the standpoint of restraint, which I know is what some are concerned about. It really, that the fundamental focus is about protection. We know that, that frequently the issue is were those people who are a danger to themselves. It's not about danger to other people, although that is sometimes the case. And we've seen cases around this country where family members have been really significantly concerned. But for a whole variety of reasons, we're not able to, or we're concerned about trying to secure or proceed with civil commitment. We know that suicides are oftentimes up around this, many indications are up around this country, and we know that while suicide can be accomplished in a variety of means and through a variety of methods, we know that the most effective, swift, and lethal method is frequently at the business end or the barrel of a gun. Other states have implemented this law and have had some levels of success. It provides a clear ability for family members to address articulable and clear safety concerns. That's what the court's going to make a determination based upon. And it is an alternative to a civil commitment, which I will say is an incredibly grueling process. It's challenging. And this would allow a mechanism very similar to what happens today with those people who need to secure or obtain an order to address family issues or family violence. These are for a fixed period of time, generally for a minimum of 6 months. They can be renewed for up to 2 years. And one of the things that was unique in the bill, because one of the things that we heard loud and clear from people was that in Minnesota, the desire for people to have, to spend time with their family members and hunt and those sorts of things, which are significant and core values here, was that we try to create and craft, and much to the dislike of some, but we created language that ultimately said that in certain provisions, family members would be able to, if I had a son, as a for instance, that wanted to go hunting and they were stable and things were fine, and with some clarification, I could take my son out and they could have access to that firearm. Because the last thing we want to do is separate people from their family members. That's the last thing we want to do. So we tried to create a bill that we think addressed immediate safety and security, emergency-based concerns, but also to recognize the significance and importance of family and the temporary, what can oftentimes be the temporary nature of these issues or problems.
Thank you, Chief. Ms. Cade, do you have some additional remarks?
I do, yes. Yeah, and thank you. I'm glad you brought up domestic violence. So Chief Schnell was kind enough to share his personal experience on this issue, and I'd like to share mine now. So this is a very personal issue for me. I haven't actually shared this story before, but I grew up in a family with domestic violence. I remember the fear. I remember my mom snatching up my brother and me in the middle of the night. I remember hiding in a battered women's shelter, terrified of what would happen if we were found. And this isn't an abstract philosophical debate for me. I've lived it. The rights we guard so jealously must be applied equally to the best and the worst of us. My dad was somewhere in that gray area between the best and the worst. He did a lot of things wrong, but he still deserved the full rights and protections of a citizen of the United States of America. He deserved due process. He deserved to be considered innocent until proven guilty in a court of law. He deserved the right to defend himself from accusations made against him. As an American, I owe it to my community to see that those rights are not selectively applied. One of the responsibilities of a self-governing citizenship is to remember that the ideals of liberty persist, even in the face of overwhelming emotion. So yes, even though my heart would like to take every extreme and drastic measure to protect abuse survivors like my mom and to protect the mentally ill, my responsibility as a citizen is to protect the rights of all Americans, the best and the worst of us. Thank you.
Thank you. So that concludes our exploration of a couple state-level issues, and now we're going to turn to the federal-level issues, and we have 3 of them. Again, we had a coin toss, and Nancy Bentz is going to go first, followed by Brian Stauser. So Nancy, would you like to begin? Our first issue is Funding for research on gun violence by the Center for Disease Control and Prevention.
Well, hi there. It's great to be here tonight and a little terrifying. 117,000 Americans are shot every year. 32,000 of them die, one every 17 minutes. The American gun homicide rate is 25 times higher, and our gun suicide rate is 28 times higher than other Western democracies. Guns kill more Americans every year than AIDS, drug overdoses, wars, and terrorism combined. This year, guns will kill more Americans than motor vehicle accidents. What do we do about a public health epidemic of that magnitude? Typically, we study it. Very smart scientists at the Centers for Disease Control collect data, conduct research, submit the results for peer review, and then make their findings known to the public to help inform public policy. That's how we figured out that cigarettes cause cancer, despite tobacco industry protests. That's how we cut car accident deaths in half over 35 years, despite auto industry protests. And that's how we could cut gun violence in half as well, except the CDC leadership is afraid to study gun violence, afraid to even classify it right now as a public health concern, and by their own admission, spent $0 out of their $11 billion budget on gun violence prevention last year. The irony is the CDC was one of the first agencies to study gun violence as a public health issue. In 1993, its Center for Injury Prevention published a study that showed the presence of a gun in the home substantially increased the risk of gun-related death and suicide. When that study came out, the NRA went a little ballistic and began pressuring members of Congress to stop CDC's gun research. In 1996, Congressman Jay Dickey of Arkansas introduced the Dickey Amendment, prohibiting the use of CDC funds to promote gun control. It passed. To make sure the CDC got the message, Congress reappropriated $2.6 million that had been earmarked for gun violence research in 1997. So fast forward 2 decades. Despite President Obama's executive order in 2013 that the CDC resume gun violence research, Congress has continued to block funding and refused to overturn the Dickey Amendment. And the icy fingers of the gun lobby, there you go, Sarah, there's that word, with help from the lawmakers who serve it, have succeeded in freezing out gun violence research at many public universities and state agencies as well. Even Minnesota has suffered from the gun research deep freeze. 2 Minnesota statutes expressly prohibit the Commissioner of Health and any state agency from collecting data related to firearms and firearm ownership. I join literally thousands of well-respected academics, researchers, public health organizations, and even former Congressman Dickey in advocating for an overturn of the Dickey Amendment and resumption of funding for gun research at the CDC. I'd also like to put in a plug for overturning Minnesotans' state data collection prohibitions as well. I don't think it jibes well with Minnesotans' self-understanding of ourselves as educated, interested, scientific people when we find out that we can't even study gun violence in our own state. And I guess I would like a show of hands. Who here knew that in our state statutes, we have prohibitions against gun data collection? Not that many. And I'm done with my section.
All right, good evening, everybody. Thanks for being here. I think we probably have more common ground in this issue than we think. The issue really comes down to this. In the 1990s, as Nancy outlined, the CDC was publishing basically gun control research, and that led to a ban on the funding in the Dickey Amendment. It led to quite an uproar, what I think we would have called politically motivated research at the time. Because if you do research that has a predetermined outcome, that's not really research. Now, with all that said, it's 2016. So I don't think any group is going, at least we're not going to be opposed to doing research on gun violence, on violence in general, on firearms ownership, as long as that research is unbiased, it's refereed the way that we do scientific research. And I have an academic bent. I think I know what we're talking about here. We're talking about research that doesn't have a predetermined conclusion as we approach that research. With that in mind, I think those are things that we would support. I think the challenge is actually finding a way to do that where we ensure that that research is unbiased. So I think there's more in common for us. I don't really have a lot of commentary on this. I will point out a couple things. This ban only applies to the CDC. If you're a researcher and you go right now to the federal government's grants website, there are 17 grants for firearms violence, public health research related to firearms violence, and all kinds of firearm-related research that's available. There's millions of dollars of grant money through the Department of Health and Human Services, through the National Institute of Justice at the Department of Justice, and through the Bureau of Justice Statistics. So if you run a nonprofit, you want to do that research, you're an academic at the University of Minnesota or one of our other great institutions, that money is there. This ban is specifically relates to the CDC. And that's, otherwise I think we have more common ground on this than we think.
Well, there you go, folks. Brian, I have to ask you then, what do you think about the Minnesota state prohibitions?
I actually hadn't heard of the Minnesota prohibition, to be honest with you, so I need to look a little further at that. I think I only saw one hand.
There were a
That
few
went
over
up.
there,
Yeah,
There-
and Beth knows.
as a moderator, I just want to remind you,
Oh,
we
I'm
prefer that you speak to the audience,
we're
Oh,
but,
trouble already.
but
I'm
thanks
sorry.
for dialoguing on common ground.
I think it's great. We're kind of agreeing here, and so I don't have to say much more other than the fact that public health research and policy is such that it should be unbiased. No true public health research should be going into anything looking for a particular answer. So I think we have common ground here.
Wonderful. Let's move on then. Thank you both for your comments on that issue. Our second federal issue is reinstatement of the assault weapons ban. And for this, we are going in the opposite order. So, Brian, could you go first, please?
Okay, so let's talk about what is an assault weapon. So let me ask some questions. And we did some show of hands earlier, so let's show some hands for this. How many of you believe that in the mass shootings where you've heard the term assault weapon used, that weapon was a machine gun, an automatic weapon that when you pull the trigger, it keeps firing? Oh, this is great. Okay. How many of you, as you think about the nightclub shooting in Orlando or at Sandy Hook, believe that it was a military weapon that was used? Oh, I saw a couple hands. Okay. So if you, as we think about these definitions, this is where we get into some terms that have just been made up. There really isn't anything that's an assault weapon. This term was made up in the late 1980s by the Violence Policy Center in Washington, D.C., in order to push for an assault weapons ban that was passed in 1994. They deliberately conflated the idea of confusing military-style weapons, automatic weapons, machine guns, or scary black rifles with this idea of somehow increased lethality in the provisions of these firearms. Now, when the 1994 assault weapons ban that was federal law until 2004 really came down to this: the only way to define an assault weapon, so to speak, is to use cosmetic features. None of these bans had anything to do with the caliber of the firearm, so that's the size of the bullet, the foot per second, the speed in which the bullet is coming out of the rifle and hitting somebody, translating into the amount of force that's used. It had nothing to do with the stopping power of the firearm. It had to do with cosmetic features. And you can look at Nancy's handout here, which is from the Law Center to Prevent Gun Violence, as an example of the kind of things that were being used. It's the adjustable stock, the fact that there's a butthole, or a thumbhole stock rather, a folding stock, a pistol grip. I have a 3- and 5-year-old, so there's a lot of conversation about butts in my house. Sorry about that. We talked about, the ban talked about the ability to accept the detachable magazine, and it also referenced a barrel shroud. Now, one of the authors of this ban was Congresswoman Carolyn McCarthy from Long Island, who was a longstanding gun control advocate. And Congressman McCarthy was on video once, or on the TV, and somebody asked her what a barrel shroud was, and she goes, "I don't know, it's the thing that goes up." Well, she couldn't define what it was, but she was willing to write a law claiming about we need to ban these because of increased lethality. So this idea that the assault weapons ban is so dangerous is really made up. I'm sorry, that assault weapons are so dangerous is really made up. There's nothing functionally different about an AR-15 than the type of rifle that some of you may take deer hunting when deer season starts. It works exactly the same way. It fires at exactly the same pace. Your deer rifle is going to use a larger caliber round than what an AR-15 is. These rifles don't spray bullets, they don't fire any faster, and it's not more lethal. These made-up facts have taken such hold in the public conscious that when I was in India for work in February, I was sitting with some friends in Bangalore, and I mentioned, I'm not a hunter personally, but some friends of mine had just recently had deer hunted using an AR-15 for the first time. And my friends looked across the table and said, well, how can that be? Because after the deer was shot, there wouldn't be any meat left. And that's just entirely not true. So there's a great public misconception about what we're talking about and about the fact that these are not any more lethal than your typical rifle. The AR-15, by the way, is the most commonly used hunting platform in the United States. It's the most commonly owned rifle in the United States. Thank you.
Thank you. Ms. Benz, would you like to take your time, please?
Yeah, I would. First of all, Brian, I know what a barrel shroud is. I'd like to begin by acknowledging that the 1994 federal assault weapons ban that expired in 2004 had so many loopholes that gun manufacturers were able to get around it really easily. Thus, it didn't accomplish as much as we would have liked, but it certainly saved lives. We know that because there has been a 275% increase in the victims from assault weapons since the ban expired. Now there is a new, improved assault weapons ban before Congress, H.R. 4269. This is a great bill, and it should be passed. H.R. 4269 bans the import, sale, manufacture, transfer, or possession of all semi-automatic rifles that can accept a detachable magazine and include any one of several features characteristic of military-grade weapons, as shown on my handout. It also bans large-capacity ammunition magazines, which is important. Right now, federal law prohibits hunters from having more than 3 shells in their shotguns when shooting ducks, but doesn't limit the size of magazines on guns that shoot people. H.R. 4269 does permit the continued possession and sale of grandfathered assault weapons and large-capacity magazines already in circulation, provided they're securely stored. A licensed dealer must conduct a background check prior to sale, and law enforcement agencies must be notified if a prohibited person attempts to buy one. Funding is provided in the bill for government buybacks. The bill specifically exempts traditional firearms that are manually operated by bolt, pump, lever, or side action, basically all sport rifles and shotguns. It also exempts possession of assault weapons by law enforcement personnel. Finally, H.R. 4269 does not require any new record-keeping or registration requirements on grandfathered assault weapons or large-capacity magazines. So why is an assault weapons ban necessary? Brian has called the term assault weapon a name made up by people like me to describe guns that look super scary, but are really no different than that hunting rifle you got from your grandpa or the handgun you bought to protect your home. That's just not true. Saying a semi-automatic assault weapon with a large-capacity magazine is no different from a hunting rifle is like saying a tank is no different from a Honda Civic. Like tanks, semi-automatic assault weapons are weapons of war designed for the express and exclusive purpose of killing human beings with great speed and efficiency. A firearms expert explains the difference this way. Semi-automatic assault weapons turn murder into mass murder and victims into hamburger. The assault weapons that would be banned by H.R. 4269 have 2 to 3 times the muzzle velocity of other guns. Bullets fired from these weapons hit their targets at much greater speed, causing far more serious injuries. Instead of breaking a bone, they shatter a bone and neighboring bones as well. Instead of slicing through intestines, in the words of a trauma surgeon, they literally cause intestines to explode. The assault weapons that would be banned can shoot as fast as the shooter can pull the trigger, up to 45 rounds per minute. They are outfitted like military weapons with pistol grips, thumbhole or butthole stocks, I think he said, and barrel shrouds to make them easier to control during rapid firing. As mentioned earlier, they are designed to hold large capacity magazines, devices also banned by the bill, that can hold up to 100 rounds of ammunition. So in less than 2 minutes, a shooter with a semi-automatic assault weapon can fire nearly 100 rounds at high velocity with great accuracy before having to pause to reload. And that's often the only time that the shooter can be stopped. Research has shown assault weapons result in significantly more victims per incident than traditional firearms. One study showed them averaging 135% more injuries and 57% more deaths per mass shooting. And they are increasingly the weapon of choice to kill law enforcement officers. So far this year, 30% of police officers killed in the line of duty were slain with assault weapons. These weapons are giving drug runners, street gangs, and even terrorists the upper hand. A police captain from Brockton, Massachusetts, described it in these words: "We are literally outgunned. You're talking about the kind of firepower that can go through vehicles, through vests, that can literally go through a house." For all these reasons, leading public health and criminal justice organizations, including the American Academy of Pediatrics, the American Public Health Association, the American Bar Association, and the International Association of Chiefs of Police, have all called on Congress to enact an assault weapon ban. 7 states and the District of Columbia have already enacted assault weapon bans, and others, including Minnesota, regulate assault weapons differently from sporting guns, which makes sense because assault weapons are not sporting guns. Just ask hunters. 67% of Field and Stream readers said that assault weapons have no legitimate sporting purpose. They are not common use weapons. They are weapons of war that should be banned.
Thank you. Mr. Strausser, do you have some follow-up comments?
Yep. Okay, so let's talk about some other facts around this, now that we've heard Nancy's information. So in all of the homicides in the United States in 2015, rifles of any type were used in 1.4% of homicides. 1.4%. Now, we don't track the number of deaths, homicides that are involving assault weapons because the FBI doesn't consider the number to be significant enough to track it. So this 275% increase that I'm hearing is still in the double digits in terms of a number. So we're talking about less than 2% of homicides in the United States. They're used in less than 0.25% of the violent crime in the United States. In Minnesota, it was less than 10 homicides in 2015 involved rifles of any type. We don't know what type of rifle. We just know that there was a rifle involved. We had a ban on assault weapons from 1994 to 2004. It was completely ineffective. And you don't have to believe me to believe that. You can go to the U.S. Department of Justice website. You can read their study on the effectiveness of the bill, which said it was ineffective. You can read the University of Pennsylvania's study on the bill that also said it was ineffective. And I'll reiterate the point that it is the single most popular hunting platform in Minnesota and across the United States, regardless of what the readers of Field and Stream believe. Thank you.
Thank you both. So we're going to turn to our third issue, and just for the audience's benefit, there was another coin toss to decide what order folks went in for this one, and we'll be starting with Reverend Bentz. And the issue is, I'm sorry, the no-fly list prohibition.
9/11 and the terrible terrorist attack dramatically affected the nation and the rest of the world. The attack stimulated a concerted effort to adopt measures that would reduce the risk of terrorism in the future. Many of these precautions have encroached on civil liberties. The question before us this evening is, should Congress pass legislation that would prohibit those on the terrorist watch list from purchasing firearms? And if so, which version of legislation should be passed? What we generally call the terrorist watch list is the U.S. government's consolidated database of known and suspected terrorists. It has approximately 1 million total names, of whom fewer than 5,000 are Americans. These numbers are important because the Second Amendment only applies to American citizens. So what happens once one gets on this list? Well, sometimes they're arrested and tried for terrorism. But even when the authorities don't have enough evidence to make an arrest, American citizens on the watch list can be denied visas, denied entrance or re-entrance into the country, denied boarding on commercial flights, and surveilled by federal, state, and local law enforcement. In all these fundamental ways, our government can encroach upon the civil rights of those on the terrorist watch list. But it can't keep them from legally buying a gun or from buying explosives. If you're like 83% of Americans, you might think that's pretty crazy. After the Orlando massacre, when it came out that the shooter had actually been on the terror watch list at one time, it seemed even crazier. So the Feinstein-King no-fly, no-buy bill was introduced in Congress. The bill would give the Department of Justice sole discretion over which terror suspects could purchase weapons and explosives and which could not, so as to protect the secrecy of ongoing terror investigations. Anyone unfairly targeted could appeal in court. Of course, when the NRA and its congressional supporters saw the provisions in the Feinstein-King bill, they cried, "Oppression. What if someone were erroneously placed on the watch list? How could we justify taking away an American's Second Amendment rights based on suspicion that he might be a terrorist?" The NRA drafted a competing bill that would make it incumbent upon the Justice Department to prove within just 72 hours that the person on the watch list was indeed a terrorist before he could be prohibited from buying guns or explosives. If DOJ didn't accomplish that within 72 hours, which would literally be impossible if the case depended on classified intelligence from the CIA or NSA, then the subject would be free to purchase. He could also, by this time, be fully aware of the fact that he was under investigation for terrorism and would be aware of most of the evidence the government had assembled against him. Now, here's the funny thing about the NRA bill. The government would be bending over backwards to prove the suspect's guilt in 72 hours, very possibly derailing an ongoing terror investigation, in order to give fewer than 5,000 individuals a special due process hearing. Meanwhile, there are 30 to 40 million other American citizens who are prohibited from buying guns, mainly felons, but not all, and no one in these groups gets the kid glove treatment from the government. If you're a member of a prohibited purchasers group, your right to purchase a gun is prohibited even if your crime is in the past and you've paid your debt to society. The NRA bill would assure special treatment for one protected group, suspected terrorists.
Thank you. Mr. Strauser, you have time
Sure.
to respond.
So I don't really view this as a Second Amendment issue, and I don't think most of our supporters here in Minnesota view this as a Second Amendment issue. This is really a due process issue in our mind. I think Nancy described the basic references accurately here that we're really talking about, and we often conflate the Consolidated Terrorist Watch List, which is about 1 million people, and the no-fly list, and they're a little bit different, but for purposes of this discussion, we can pretend they're one and the same. They're both run by a consortium of the FBI and the Transportation Security Administration, the TSA, everyone's favorite government agency. But at the core of all of this, here's the issue. There isn't a government official who decides to put you on a list. You don't know you're on the list. You don't know how to get off of the list, and you have no idea why you were put on the list. And then you go to exercise a specific enumerated constitutional right the right to purchase a firearm for self-defense, as we heard upheld in the Heller case, and you're denied. You have no route to appeal. You have no way of knowing why you were denied, and there's no path forward for you out of that situation. What other constitutional right do we do that to? We don't stop you from speaking in public. We don't stop you or take away your right to be free from search and seizure. We don't start torturing you because you suddenly no longer have your Eighth Amendment rights. We don't allow the police to search your home without a warrant because you still have all of those other constitutional rights. That's what this comes down to for us. This is a due process issue. None of us believe, and nobody here believes, I would hope, that terrorists should own a firearm or be able to obtain a firearm, but this is not the way to go about doing that. There was Nancy made a reference to, this is a special due process provision, and I don't agree with that characterization. We have millions of people that are prohibited from owning a firearm, that are in the FBI system that is used in the federal background check process. These people have had due process. They have been convicted of a felony. They have been convicted of misdemeanor domestic abuse. They have been convicted of domestic abuse involving a weapon or violence. They have been adjudicated by a judge in a process with representation that they are violently, dangerously, mentally ill, or chemically dependent, or one of a host of other prohibitions that are in the federal law and in the state laws that govern these issues. They have had due process. This is a government official putting you on a list. Now, I'm not a conspiracy theorist, but I lived in Massachusetts for 8 years. Massachusetts, and I love Massachusetts, I'm a huge Red Sox fan, but the state has a firearms law provision that to me is nutty. Although some of you here will probably like this. In Massachusetts, you have to get a permit from your police chief. There are no sheriffs, there are no counties in Massachusetts. You have to get a permit from your police chief to even own a firearm. And the chief can decide to revoke that at any point in time, for any reason. And they can also change the conditions so that you can't own a handgun, you can't own a shotgun, you can't own a rifle. They can put all kinds of crazy restrictions on there. That's the same issue here. I'm well aware of an incident that will resonate with some of the gun rights folks that are here, where a blogger who made some unpopular political comments, at least in Massachusetts, the police chief decided that individual should no longer own a firearm. And so they revoked his permit, and they went to his home, and they seized all of his firearms that night. That is no different than what we're talking about here. We don't allow secret lists made by government officials to infringe upon your constitutional rights without due process. And it should worry all of us that we're talking about and supporting a law such as that. That's it.
Thank you. Nancy, do you have any
Sure.
additional comments?
Well, let me tell you why it's so important that we keep those on the terror watch list from buying guns, even if it means that some people will have their constitutional rights curtailed. On June 17th, 2015, 9 people were slain in a terrorist attack at Mother Emanuel Church in Charleston. The shooter, Dylan Roof, was a white supremacist hoping to start a race war. 2 months before, he went to buy a .45 caliber Glock, and although he should have been barred from purchasing it because of a prior drug arrest, Roof was able to buy the weapon after an investigator was unable to find his paperwork. Under federal law, the criminal background check has to be completed within 72 hours, or the sale can proceed, just like the NRA's no-fly, no-buy legislation. Because the clock ran out, 9 people are dead. Now imagine if instead of working alone, Roof had been part of a terrorist group. And imagine if instead of buying that Glock, he'd purchased a semi-automatic weapon. Imagine if instead of attending that Bible study at the church, he and his comrades had gone to Market Street that evening and opened fire on the crowds there. Imagine how many more lives they could have taken. We think about terrorism as suicide bombers and airplanes crashing into towers, but more than 75% of recent terror attacks in the U.S. have been with guns, and those have been some of the deadliest. It is imperative that we keep those on the terror watch list from buying guns. Thank you.
Thank you all panel for helping us explore those 5 very important and current topics. We have about 15 minutes left in the forum, and so we're going to turn to some questions. We're going to put a 1-minute limit on each of your answers. If you don't feel like you need to answer, that's okay. It's not a requirement that you answer, but we will start, and I think for the first question, we'll run from this end of the panel down to the other end, and the next question will run on the way back. So the first question is, what are the criteria for judging during a background check? What and how many negative, quote-unquote, negative marks would mean failure of the background check? So they apparently want to know more about how background checks work.
Okay, I'll start this one, and then I'll let Brian take it over for me. So I think, if I understand the question correctly, it was how many disqualifying marks do you have to have before you fail a background check? Was that?
That's one of them. That was the second follow-up question. The first one was, what are the criteria for judging yes or no during a background check?
Okay, so that criteria is specifically spelled out in Minnesota law, just to avoid the problems that we talked about with the terrorist watch list, where somebody can say, oh, you look shady, maybe not you. Or like Brian was saying with his police chief, oh, you spoke out against me politically, maybe not you. So anything that denies you in Minnesota is specifically enumerated. And I think Brian can probably give you a little more detail on the exact requirements. But the basic answer is that it's things like previous violent felonies, misdemeanor domestic violence convictions, being adjudicated mentally ill or incompetent, stuff like that. So I'll turn it over to Brian.
So Minnesota law and federal law mirror each other, at least as of 2013, I think it was, that we made some changes. So the prohibitions are a one strike. You're either a prohibited person or you're not. So federal Minnesota law are the same. If you are a convicted felon, you're prohibited. If you've been adjudicated violently mentally ill through due process, you're prohibited. If you've been dishonorably discharged from the military, you're prohibited. If you're under any type of restraining order alleging violence, you're prohibited. And I'm probably missing a few things. That's what randomly or mostly comes to mind. Minnesota law adds a second provision to this, which is that if you're buying from a dealer a handgun or what Minnesota defines as a semi-automatic military-style assault weapon, which essentially is any firearm that takes a detachable magazine, you need to have a permit to purchase or a permit to carry. The permit to purchase is free. You get it from your police chief. And that allows there's some other mental health investigation. The chief can probably speak better to this than I can. Permit to carry you get from your sheriff, and you have to pay a fee, go through a class, but it acts as a permit to purchase.
And I think they covered the majority. I mean, the criminal, it's the order for protections. We check the DHS database on prior civil commitments and check for the existence of orders for protection or certain types of harassment restraining orders that may prohibit gun, the ability to possess or purchase a firearm. But really, that's those items were covered. I mean, there's there's some challenging issues because you can also have instances where where we have cases that I have signed off on permits to purchase on people who have had really significant domestic violence cases, but for whatever reason, that case was pled down to a disorderly conduct or something like that, and that person would not be prohibited and would have access to that firearm.
Well, the only thing I have to add is I thought of a couple more groups: undocumented immigrants, fugitives from justice, and then in Minnesota, it's age, isn't it 18? That's considered, you have to be 18
To buy a handgun.
buy a handgun.
Or a semi-automatic military-style assault weapon.
There you go.
Yep.
All right, thank you. The next question has to do, well, I won't characterize it, I'll just read it. State gun laws vary widely. Would we be better off with consistent legislation from the federal level? And then it goes on, the readers decided, the folks who read the questions decided these were related. So that's one part of the question. The other is, or would you support a state firearms registration system? So, Ms. Bentz, if you could
Starting
start
with
and
me
we'll
on
move
this,
on this
huh?
way.
Well, I'm going to first address the federal thing. I think in a lot of ways, consistent federal laws would be very helpful, particularly in gun trafficking. You know, we're always hearing about how Chicago has, you know, so much murder, so much gun violence, and they've got such good gun laws. Well, Chicago has guns coming in from all over the country, and particularly states like Indiana. And so if we had consistent federal gun laws around straw purchasing, around closing the background check loopholes, mandated lost and stolen, we could really do a lot to help in that regard. And I'm out of time, so I will hand it over to the chief.
I think, you know, in essence, you know, I would agree that the federal stuff becomes more consistent. State law does become local. I think local communities local states get to select some of this, but it does create some challenges because you can walk across the border and it could be different there, and that's one challenge. The issue of registry, I think, is not something that, you know, that I think has been on the table. There's arguments for, against. But the fundamental issue is, I think if we can start to do a better job of just requiring people to go through a background check, that addresses much and many of the concerns that I think all of us have, because we know that these background checks do make a difference.
I think we have a proud Federalist tradition here in the United States. We have a lot of laws that are at federal level. We allow states to do several different things when it comes to laws. I think I don't really have a strong opinion on this. I think that we're used to the fact that we address some issues federally. It's more difficult to prosecute criminal cases federally. Funding becomes much more political, so I think those are issues to keep in mind. Most of your firearms enforcement happens at a state level with local police departments and groups like the BCA and others. What I would never want to see is any type of patchwork legislation across the state. Minnesota today only allows the state legislature to regulate firearms. We don't let cities pass their own ordinances. I don't know how you would go. I passed through 4 cities from my home to my office. I have no idea how you could navigate the state if there was a patchwork of laws at that level. And of course, in terms of a registry, we would be completely and utterly opposed to such a thing and would fight tooth and nail if that topic came up.
Okay, and to kind of take over from Brian a little bit, he addressed the first question pretty well. Not all areas have the same concerns. So, of course, a federal law might not really address problems that you might have in particular states. Now, the gun registry issue is not really a Second Amendment issue. It's a privacy issue. So, as far as that goes, it's basically nobody's business how many guns I own, what kind of guns I own. I'm not willing to give any of my personal information to a system that can be hacked or, that's insecure. So that's kind of one of the issues there. The other issue with that is that as more and more restrictions are imposed, having guns that are registered is just a way to identify who has what and say, maybe this person's a problem when they're really not. So, oppose.
Okay, thank you. Professor Steenson, if you want to jump in, you're part of the panel as well, if you have any inclination. If you want to answer any questions, you can. I should use the microphone. If you want to answer any questions, you certainly feel free to jump in.
The wheels are spinning in my head.
Okay.
In a sense, it's a privacy issue, but there can be gun registration laws. Of course, that was at issue in part in the Heller case. And so there is an issue if you can only carry a registered firearm, but you're not allowed to register that firearm. It can become a distinct Second Amendment issue. And on the question of federal uniformity, assuming that could ever be achieved, then we'd defeat one of the basic purposes of having individual state legislation. Louis Brandeis, one of our great justices, said that there are experiments going on in 50 different states. And we don't know how those experiments are going to work out, but states ought to have the latitude to try to arrive at different results given different circumstances. And with federal uniformity, I mean, how many people, well, I guess I won't make any analogies, but once federal government legislates, once the Supreme Court takes something out of the hands of the states, then that's it. The experimentation is over.
Okay, thank you. I think I told the panelists I'm going to ask them one of my own questions at the end, but this will be the last question from the audience. Some say that only a good guy with a gun can stop a bad guy with a gun. How would you suggest that police officers would be able to tell the difference between a good guy with a gun and a bad guy with a gun during an active shooting?
Am I first for that one?
You are. We're going that direction.
The one that's trying to kill you is the bad guy. That's all I have to say.
So I think this is Wayne LaPierre, the CEO of the NRA's famous comment after Sandy Hook that the only way to stop a bad guy with a gun is a good guy with a gun. We kind of laugh at Wayne sometimes because he doesn't always represent perhaps gun owners the way that we want to be represented. So let me address that in a different way. There is sound evidence around the fact that when you're in an active shooter situation, that the way to end the active shooter situation, based on the data from the FBI's report on analysis of active shooters, is to quickly engage the shooter with lethal force. Because when they're engaged, they stop. That was the major tactical change that police made following Columbine. So now that we got that out of the way and they're kind of the root of where that quote came from, there have been situations where permit holders have been lawfully carrying a firearm, have found themselves in a situation where there's a bad guy and the police are involved. And so far, I'm not aware of a situation where the permit holder was shot and killed or a law enforcement officer was shot and killed in that situation. But it's definitely a sticky situation to be in, and one that I hope that we can find some better solutions around.
I would just say this. Look, in an active shooter situation, we want it to stop for the safety and well-being of our kids, the people in that business, the people in that mall or movie theater. That's the bottom line. At the same time, I think there is a tremendous risk here that in that response, you aren't going to know. Because the problem with waiting until if somebody's going to attempting to kill you when they're shooting at somebody else, it may be too late. So these are just the difficult things that I think we're going to have to balance, but we want, ultimately, we want people who are under attack to be safe.
I guess I would just remind us all about the Dallas shooting and how it was a peaceful protest. The police were not dressed in, white riot gear, and there was I think it was a Second Amendment demonstration going on during that, and that was peaceful as well, but a lot of guys had guns. And when the shooting started, of course, everyone ran. It's appropriate. A sniper is shooting at you. The guys with the guns ran too, and it was very confusing for law enforcement. And in fact, one of the first picture that they put out that they were looking for was a guy that was peacefully carrying his gun, but the cops were confused and thought he was a shooter. And so I do worry about the idea that in a shooting situation, I worry about our cops having to decide when they see someone with a gun, is this a good guy with a gun or a bad guy with a gun? I think we're all very concerned about police shooting first and asking questions later, but at the same time, we have to recognize the fact that they are in real danger when they're faced with someone with a gun.
Thank you, panel. And as I gave you a little heads up, I'd like to know, and I hope this will be useful for the audience, is there a book or an article that you would recommend for people to continue their education after tonight's forum? So let's start with Nancy.
Well, if you want to get into the idea of studying gun violence from the point of view of a public health perspective, and that's the perspective that Protect Minnesota has traditionally taken, I would encourage you to try to wade through Private Guns, Public Health by Dr. David Hemingway from Harvard. It's a little deep. I usually eat it a bite at a time, but it does give you a chance to think about gun violence as the point of view of a public health issue.
So I'm not as sophisticated here about books and publications. I mean, I think we know that there's a tremendous amount of information that's available to us that representing every view and every perspective. And I think we should try and get as much of that as possible to understand and value the perspective of others, but ultimately to make our own decisions. And that's really what the importance of this forum has been, and that's the importance of these discussions tonight and going forward. So arm ourselves with as much information as we can possibly get, and there's a plethora of it out there.
So I like thinking about things and reading things that challenge my own point of view. And when I think about the Second Amendment, I originally was more on this end of the table when I was in college, and my views have evolved over time to where I am today. One of the things I read that really influenced me was an academic paper, actually. So for the nerds out there, it's called "The Embarrassing Second Amendment." It's by Dr. Sanford Levinson, who's a professor, I think, out in Colorado. But he's a liberal who thinks that he wanted to look at the kind of founding fathers' documents and other things about the Second Amendment, thinking he would come up with this point of view that that guns were bad and the Second Amendment didn't really mean what it meant, and came around to the point of view that I hold today, as you heard from the professor earlier. So the Embarrassing Second Amendment, Sanford Levinson.
Okay, I'm not as serious as the rest of these guys. So as a person of color, I like to read uplifting things about my culture, and so I would recommend the book Negroes and the Gun, The Black Tradition of Arms by Nicholas Johnson. So it takes a look at some of the self-defense traditions originating even before the abolishment of slavery, and it continues that historical perspective all the way up to present day. So it's very interesting.
Who's that author?
And I would really,
I'm sorry.
Sorry.
Go ahead.
I would strongly encourage you, hard as it is, to read the Heller case, so that you understand the difficulties that courts, our highest court, Supreme Court of the United States, has in dealing with these issues. So District of Columbia versus Heller, you'll find the full opinion on the internet. You can see dueling arguments by Gura, G-U-R-A, who argued Heller and won in the Supreme Court of the United States, and a fellow by the name of Rostron, R-O-S-T-R-O-N, who takes the opposing point of view. You'll see articles by both of those readily available on the internet, but take a stab at reading Heller. Take a stab at reading it so you see just exactly what it is that the courts are struggling with. You'll be able to do it.
Thank you so much for that diverse array of recommendations. I myself like to challenge my own point of view, and so recently I have enjoyed reading Gun Guys, which is an opportunity for me, a person who's not very familiar with guns, to explore a variety of worlds that do involve people who are deeply connected to their guns. So thank you. Please join me in thanking the panel for their time and their wisdom. And also thank you to the League of Women Voters of Bloomington for sponsoring this forum. And I want to thank all of you for being a very attentive and courteous audience as we explored various viewpoints on these issues. This concludes the forum. Good night.